Hello, everybody. Welcome. I'm just going to give it a couple more seconds here for all the attendees to join. All right, let's get it started. So we are the Colorado HOA Information and Resource Center. Thank you for joining our HOA forum. Sorry, I had a quick technical issue. There we go. All right, sorry about that. We are the HOA Information and Resource Center. This is the HOA forum for October 2025. The topic of today's presentation is House Bill 25-1043, which is the Colorado HOA Collections and Foreclosures Bill. So this is a large and comprehensive bill, and I'm looking forward to hopefully explaining as best I can what the key provisions of this bill are and how they might or likely will impact your HOA community. My name is Nick Altman. I'm the HOA Information Officer, and I also have support from my colleagues David and Amanda. And let's go ahead and get started here. So just as a quick disclaimer, if you don't already know what the HOA Center does, it provides information to homeowners regarding their basic rights and responsibilities under HOA. It's also statutorily charged with collecting and tracking HOA complaints, as well as maintain a database of all the HOAs in Colorado. The office also creates resource materials and provides education and forums, such as this one. And the office also is required to provide an annual report to the state legislature. What the HOA Center is not able to do, or what it's not statutorily authorized to do, is mediate or arbitrate on behalf of homeowners, board members, or community association managers. It's unable to act as an advocate, assess fines or penalties, or act as a regulatory program. And just for another disclaimer, the information included in this presentation is not intended to be construed as legal advice. It's for educational purposes only. And I would like to get us started with a couple polls today to kind of gauge our audience and the audience's level of knowledge with respect to HOA law. Bear with me and I'll get these launched here. Okay, so you should be seeing on your screen, on your Zoom screen, we would just like to know who you are basically, homeowner, member of an HOA board, community manager, an attorney, a real estate broker, or other. And I will share these results here in 7 seconds once all the data comes through. All right, let's see if we can see the results here. It appears most of our attendees are HOA board members, followed up by homeowners or members of HOA communities, as well as various other parties. So thank you, board members, for joining. Let's see, should get my second poll here. Oh, yep. Okay, so poll number 2, Kiowa is a sort of a true-false question. Kiowa requires a policy concerning the collection of unpaid assessments. Is that true or false? All right, looks like 86% said true, and that is the correct answer. Kiowa does require a policy concerning the collection of unpaid assessments. Let's see, 3. All right, question number 3. Limitations on enforcement. So an association, true or false, an association is not entitled to reimbursement of attorney's fees that exceed $5,000 or 50% of the assessments and any money owed to the association with respect to a unit owner's delinquency. All right, the correct answer is true, according to this new bill that we will discuss. So an association is not entitled, according to House Bill 25-1043, to reimbursement of attorney's fees that exceed $5,000 or 50% of the assessments and any money owed with respect to a unit owner's delinquency. I got two more here. Question number 4, true or false? With the passage of House Bill 25-1043, an association's substantial compliance with Kiowa is sufficient as a condition precedent to recovering money owed to it through the foreclosure of an association lien. True or false? All right, the correct answer is false. So with the passage of 25-1043, an association must strictly comply with Kiowa in order to recover money owed to it through the foreclosure of an association lien. And I'll discuss the difference between substantial and strict compliance here in a couple minutes. Okay, last poll. Limitation on liens for assessments. So true or false? Fees, charges, late charges, attorney fees, fines, and interest charges are subject to a foreclosure action under Kiowa. True or false? All right, the answer is false. Correct answer is false. Only assessments are subject to a foreclosure action under Kiowa, not fees, charges, late charges, etc. All right, so I hope you found that poll enlightening. Let's advance here with the presentation. Okay, so House Bill 25-1043, short title is Owner Equity Protection and Homeowners Association Foreclosure Sales. It's also known as Concerning the Protection of Unit Owners in Relation to Enforcement Actions by Unit Owners Associations. The prime sponsors of this bill were Representative Nikita Ricks, Representative Jennifer Bacon, and Senator Tony Exum. This bill was introduced January 8, 2025 in the Colorado General Assembly. It became law on June 4th, 2025, and the effective date of this bill is October 1st, 2025. So key provisions of this bill and what I'll be talking about today include determining reasonable attorney's fees and the notion of strict versus substantial compliance, an HOA collection, certain modifications to an HOA collection enforcement procedure, certain enforcement changes, certain changes to Colorado foreclosure sales, which while they are non-Kiowa related changes, they still do apply to HOA community legal matters. And then lastly, the changes that the HOA Information and Resource Center is required to implement with respect to registration data that it collects as part of the Colorado HOA registration requirement. So number 1, determining reasonable attorney's fees and the notion of strict versus substantial compliance. To begin with this section, it's important to realize or to know that if an association wants or seeks to collect money owed to it, collections costs, or reasonable attorney's fees through the foreclosure of an association's lien, then the association must strictly comply with the Colorado Common Interest Ownership Act, or Kiowa, and any applicable lien or foreclosure provisions of the association's declaration, bylaws, articles, and rules and regs. So that's a lot of compliance. It's a big change. The association must strictly comply with Kiowa, as well as the association's declaration, bylaws, articles, and rules and regs. If a court determines that an association is not in strict compliance with applicable law, then the court may stay the foreclosure proceedings to grant the association a reasonable period of time to come into strict compliance with the law. During the stay-in proceedings, the association is not able to assess or accrue late fees, interest, or other delinquency charges against the unit owner. And the statutory citation is included at the bottom of that slide if you would like to look up these sections yourself. But essentially, this is saying that the association has an obligation to ensure that it's complying with Kiowa. If a court finds out that it's not complying with Kiowa, a long period, duration of time will occur where proceedings will be dragged out to allow for the association to fix any compliance issues that it might have encountered during the foreclosure of an association lien. During this time, which could be 9 to 12 months or longer, the HOA cannot assess late fees, charges, etc., while it's attempting to come into compliance. So moving into how this bill also changed ways that a court may consider how to determine reasonable attorney's fees relating to the foreclosures of these liens, of these HOA liens. It's important to note, the bill law already exists. As you know, if you're an attorney on this call, you certainly know that there's already law that determines how a court can consider reasonable attorney's fees. With the passage of this bill, it added one important provision, which you'll see on this list coming up, highlighted in blue text. But let's just start the list here. So factors a court may consider in determining reasonable attorney's fees. First, they'll consider, or they might consider, the amount of the unpaid assessments. So what that balance is. Two, the court will consider whether the amount of the attorney fees requested exceeds the amount of the unpaid assessments. Number three, a court may consider whether the amount of time spent or fees incurred by the attorney are disproportionate to the needs of the case, considering the complexity of the case or the efforts required to obtain the unpaid assessments. Now, number four here is what House Bill 1043 added to this list of requirements, which is whether the association incurred inflated or duplicative attorney fees due to a stay in court proceedings, subject to subsection 3, for the association to come into strict compliance with applicable lien or foreclosure provisions of this Title 38. When we say of this Title 38 is Kiowa, or real property records in Colorado revised statutes. So essentially, attorneys cannot assess duplicative or inflated fees while the association is attempting to come into compliance. And then there's two more. 5, whether the foreclosure action was contested, and then number 6, other factors typically considered in determining an award of attorney fees. And the section of Kiowa is included on the bottom there, which is 123(1)(f). So now that we've discussed ways that a court may consider how to award attorney's fees, it's important to move into the notions of strict and substantial compliance, which is highlighted in this bill. So let's begin with strict compliance. Essentially, strict compliance means that the association has to follow Kiowa and all of its governing documents to the letter. which means every single procedural step has to be followed and adhered to. No deviations from Kiowa or the governing documents can occur. The association should be aware that even the slightest deviation could result in the foreclosure action being delayed or contested or challenged, as well as financial penalties levied onto the association. So again, I'm not an attorney. This office cannot offer legal advice, but just in my experience here, I wanted to include some possible examples of what it might look like to not be in strict compliance with Kiowa. This, of course, is not tried and true, and you might want to speak with an attorney for assistance in understanding this notion. But for example, if the association did not record a formal vote in the meeting minutes to send an owner to collections, that might be considered to be not in strict compliance with Kiowa. Also, requiring an owner to pay more than $25 per month on an 18-month payment plan that's currently required per Kiowa could be considered not being in strict compliance. And then finally, the association refusing to send official legal notices to the owner's designated representative or in the owner's stated preferred language, which are statutory mandates per section 209.5. Again, association not in strict compliance with Kiowa might be precluded from collecting amounts owed to it. So that's strict compliance, which differs from substantial compliance, which means basically the association can deviate slightly from Kiowa and its rules and its declaration bylaws, provided the effort was made in good faith and only minor technical errors were made throughout the process. So you might wonder, what I'm not a judge, but a judge might consider certain factors, whether an association was trying its best to follow Kiowa and its governing documents. Potential examples might include, the association incorporated as a nonprofit entity, but just forgot to file the periodic reports to the Colorado Secretary of State's office, and therefore being delinquent on certain reports. The board may have, attempted to send legal notices by regular mail, but just forgot that it was supposed to be sent by certified mail, or applying payments to fees and fines first prior to assessments. So again, these shouldn't be construed as like absolute fact, just hopefully provided to help the attendee understand these types of legal compliance matters that are included with this new House bill. All right. So number 2, HOA collection enforcement and procedural modifications. So the law currently states that, the law currently states that all common interest communities created in Colorado, regardless of when they were created, must have a policy concerning the collection of unpaid assessments. I included the statutory citation there, which describes which sections of Kiowa apply to pre-Kiowa communities. And if you review that section, you'll see that these 9 good governance policies that are required per Kiowa apply to both pre-Kiowa and, quote, post-Kiowa communities. Notwithstanding any date that the community was created, every HOA has to have a policy concerning the collection of unpaid assessments. This new House bill requires certain information to be added to those collection policies. So one may consider or think, well, in order to add information to a policy, the policy has to be updated or amended, right? That's a pretty good assumption. So what new information must be included in the collections policy? Text in blue indicates new material added as a result of House Bill 1043. This may be a little tricky to understand just because the text in blue is kind of embedded within the paragraph, but prior to 1043, all collections policies had to include the name and contact information for an individual for a delinquent unit owner to contact to request a copy of the unit owner's ledger in order to verify the amount of any debt or the debt. So 1043 then comes along and requires the following language or information related to this added to the collections policy. So which copy of the ledger must be provided to the unit owner no later than 7 business days after receipt of the unit owner's request. So the collection policy had to include the name and contact information for an individual who a delinquent owner can contact. Now, the association has to provide that ledger no later than 7 business days after the owner requests the ledger. So 7 business days. What else? What else needs to go into these to your collection policy? Again, prior to 1043, the policy had to include certain information related to, if an owner is delinquent, that failure to cure the delinquency could result in the account being turned over to a collection agency, a lawsuit being filed, and the filing of a lien against the property. So now with the passage of 1043, this same information or this additional information has to be added to the policy, that the sale of the unit owner's unit at auction to pay delinquent assessments, which could result in the unit owner losing some or all of the unit owner's equity in the unit or other remedies available under Colorado law. So essentially, it's like a disclaimer to a delinquent owner that, hey, if you continue to be delinquent or if you fail to address this delinquency, your unit could be sold at auction, which could result in losing some or all of the equity in your unit. Okay, moving on. Let's see. So this section right here is brand new. So now HOA's collection policies have to include this information. I don't know. I can't tell you whether this language itself has to go into the collection policy or just information that's related to this information has to be included. That would be a question to direct toward a qualified attorney or legal counsel. However, collection policy has to state something along the lines of how a unit owner can access certain information related to what is an assessment, what is an assessment of collection of assessments, the association's ability to foreclose an association lien for unpaid assessments and force the sale of the unit owner's home, and that they have information available to them from the Federal Department of Housing and Urban Development concerning credit counseling before foreclosure that may be accessed through a link on the Department of Local Affairs website. So this information has to go into that collection policy. To kind of help out our attendees, I thought it would be helpful to include suggested or possible language, which may satisfy this requirement. So in the policy somewhere, you might consider stating something like, using a web browser, navigate to https://dre.colorado.gov/HOA-center, and then scroll down and click on the header entitled Assessments and Delinquency Info. So if I can change my screen here, I might be able to give you a quick walkthrough of how to, actually I'll do that at the end, but this is how you access information on the HOA Information and Resource Center's website pertaining to this new law. So important things to keep in mind if you are a board member or represent an HOA board of directors. The board now needs to periodically request from unit owners a telephone number for phone calls, a cellular number for texts, and an email address for emails to be used for legal delinquency notices. And this is a statutory mandate. So You might ask, well, what is periodically? Like, how often are we required to ask for contact information? So while the statute doesn't define it, I'm sure your community has procedures in place on how it's ensuring that it has reliable and accurate contact information for unit owners. If it doesn't, it should probably look at defining those policies and procedures. However, annually would probably be a good rule of thumb. These efforts, these requests should be documented in writing. Maybe a board member might document the association requested contact information from unit owners on so-and-so date at so-and-so time, and retain that record in the association's official written records to ensure that it's meeting these new statutory obligations. Sort of maybe a tip and trick or something like that could be, maybe the board would want to include an official request of some sort at its annual members meeting, at the budget meeting, or other meetings where it knows where it expects the greatest number of owners to show up or attend. Maybe in the newsletters that are mailed out, you want to include, hey, make sure that you have members, make sure that you have accurate and updated contact information on file with the association, to ensure that you're receiving important notifications or something like that, or any other forms of outreach that the HOA may currently be utilizing. Just make sure that you're periodically requesting contact information from owners. One thing to consider and to be mindful of is that the statute does not require owners to provide an email address, just that the association request one from unit owners. So the legal obligation is falling on the HOA to request an email address, not on the owners to provide an email address. So I can hear the groans already, but thankfully, House Bill 25-1043 does provide a small allowance for HOAs. What if the unit owner does not respond to the request or refuses to provide certain contact information? 1043 does provide that the association is then permitted to send legal delinquency notices by regular mail. So with that, just ensure that these efforts are being documented in case it ever goes to court. Again, regular mail may be utilized only after the association has made a concerted effort to request contact information from the unit owner. Okay, moving on to section 3, enforcement changes. So if push comes to shove and the HOA decides to foreclose on an assessment lien, which is allowed per Colorado law, then a written and electronic notice must go to the delinquent owner at least 30 days prior to the action, the foreclosure action. The notice must inform the unit owner that the unit owner has a right to participate in credit counseling and that free information is available on the HOA Information and Resource Center's website related to obtaining free credit counseling and the consequences of foreclosure. So this information, so previously I talked about, what information has to go in the HOA's collection policy. While it's not frowned upon to include this information in the collection policy, the HOA just must ensure that this new information on this slide has to go into the written and electronic notice that goes out to the unit owner with respect to a legal notice saying, hey, the HOA is opting to foreclose on the association lien. So in the same notice, the same foreclosure notice has to include information on what credit counseling may entail for the delinquent owner. And that credit counseling as a service could include the following. Number one, a discussion of amounts owed to the association in unpaid assessments and related costs. Number two, the impact of what a foreclosure on the unit how it could affect the unit owner's credit. Number three, additional debt that may be incurred by the unit owner if foreclosure by the association is completed. Number four, any options that are available to the unit owner to retain title to the unit or to remain in the unit. And number five, any other options that may be available to the unit owner to avoid foreclosure. And these requirements are set forth in statute there. So it's important to point out that the HOA Information and Resource Center does not provide credit counseling or housing counseling. Rather, the information provided by the HOA Center is designed to route consumers to appropriate resources and organizations that can or will provide these intended services. And keep in mind too that the statute offers credit counseling at the unit owner's expense. So unit owners should be aware of the following list of important resources which may assist in curing a delinquency. And these resources are also found on the HOA Center's website. The U.S. Department of Housing and Urban Development is a federal agency that provides a variety of services across America, or quote HUD. HUD maintains a nationwide network of housing counselors specifically trained to help consumers make informed housing decisions. Contact information is included on the slide there. A second resource is 211 Colorado. 211 Colorado is a confidential and multilingual service that focuses on linking residents with essential services through telephone or online channels. The service operates via 4 area information centers across the state, and they can assist with various needs or other issues that homeowners may be facing, and contact information is included on the bottom. Another resource is the Colorado Housing and Finance Authority, or CHFA, I believe is the abbreviation. CHFA is an organization that helps strengthen Colorado by investing in affordable housing, business lending, and community development. And then lastly, the last resource is Colorado Housing Connects, which they offer bilingual assistance to people across the state to connect consumers with housing counseling agencies that could assist homeowners trying to fight off the pressures of rising costs. So you can find these resources on the HOA Center's website as well. So if boards should know that it's important to respect a delinquent owner's desire if they do reflect the desire to communicate through an identified designated agent or in a preferred language. This is a requirement per Colorado law. The law does not contemplate who is responsible for paying for translation services, or whether emerging online translation like Google Translate or generative artificial intelligence on, say, a Google Workspace app, for example, may offer a more cost-effective way to offer these translation services. But this should hopefully be a matter worked out between the owner and the board. All right, so 1043 also makes changes to what information must go in the NED. The NED stands for the Notice of Election and Demand, that is filed with the Public Trustee's Office, typically by the association's attorney, although I don't believe there's a requirement that an attorney file a NED. They likely have a lot of experience, though, with meeting these requirements and performing these legal tasks. So the NED must inform, as a result of 1043, a delinquent owner, a list of requirements here. that the association intends to file a lawsuit, and that if the court forecloses on the lien, that the court will order the sale of the unit at auction to pay the delinquent assessments. 2, that based on the sale price of the unit at auction, the unit owner could lose some or all of the unit owner's equity in the unit. 3, that the owner has a right to participate in credit counseling prior to foreclosure, or that the unit owner has a right to participate in mediation with the association prior to foreclosure. And that 5, the owner has access to free information through the HOA Information Resource Center, and that's not capitalized. It should be related to foreclosure by an association. Sure, I didn't skip a slide here. So notification to all lien holders identified in the property records once foreclosure is initiated must include another just additional requirements here. Number 1, that the right to cure the non-payment, information that the right to cure the non-payment pursuant to section 3838-104, and that 2, the right of the unit owner to file a motion to stay the sale of the property at auction. So it's a lot of information that has to be added to notification to lien holders in addition to the NED. This new bill also defined the word assessment, which you may be surprised to learn that Kiowa did not previously define assessment, at least with respect to collecting delinquencies. So the new definition of assessment, as reflected in 3833.3-316, is a payment for common expense obligations of unit owners based on a periodic budget adopted by the association under section 315, or a payment for limited common elements of unit owners, and includes fees specific to delinquent payments and reasonable collection costs for collecting delinquent payments. So it is a mouthful, but you may also realize that the definition special assessment is not also defined, or the word special assessment is not defined. It's my understanding that the definition of payment for limited common elements of unit owners likely could be considered what most deem to be special assessments. So that's the language you might find in Kiowa there. A payment for limited common elements of unit owners. If you were curious enough or interested enough to learn or figure out whether Kiowa defines special assessments. So amidst all these new notification requirements and collection policy changes and amendments, there are damages available to unit owners it's important to be mindful of the fact that owners can seek damages in the event that the association has violated any foreclosure laws. So if an association has violated any foreclosure laws, the unit owner, the delinquent unit owner, may, within 5 years after the violation occurred, file civil suit in a court of competent jurisdiction against the association to seek damages. And the court may award the unit owner in an amount up to $25,000, plus costs and reasonable attorney fees, if the unit owner can prove the violation by a preponderance of the evidence. So it's not a small amount, and this notion of strict versus substantial compliance should be at the top of common interest communities' legal compliance matters. All right, so 1043 also made some minor changes to foreclosure sales, Colorado foreclosure sale law. The following section is not included in Kiowa. Well, it's not included in Kiowa. Rather, it's included in a separate article of Title 38, I believe. But it's important to just mention these anyway. So what changed with respect to foreclosure sales? So now a unit owner has a right to file a motion with the court to stay the foreclosure sale in order to list the property at fair market value. Essentially, stay is just a legal term for pause or stop the action to allow for, something else to occur in the meantime. I think this provision of the bill was intended to allow foreclosed upon HOA members to retain the equity that they've built up in their home. However, they do have to exercise this right. It's not just granted to them. They have to understand that the law exists, that a right exists for them, and they have to avail themselves of that right. If an owner avails themselves of this right, they must provide notice to the association and to the quote officer, the foreclosure court officer, who is typically the public trustee or the sheriff conducting the foreclosure sale. The unit owner needs to determine the fair market value of the unit through an appraisal, a market analysis conducted by a licensed real estate broker, or another method as outlined in House Bill 1043. The unit owner may also submit an alternate value for the unit. If a delinquent owner does submit a quote alternate value, then the association may object to that owner's submittal and provide their own estimate of the unit's value to the court. Okay, so that kind of concludes the updates to what collection policies have to include and some of the changes with respect to substantial compliance and strict compliance and certain foreclosure laws. So what about the HOA Information and Resource Center's data registration collection? What are those new, what is that new information that the HOA Center is now required to collect pursuant to House Bill 25-1043? So the HOA Center now is required to collect the following information here in red. The center is required to collect it. So therefore, when a board member or community manager or a designated agent is completing the online application or renewal application for the HOA, they will encounter certain questions that are required or that they will contain a red asterisk mark. I'll include a note here at the end about the asterisk mark. But as you're working through the application, the system will not let you advance with the application until the following information is provided. So number one, in the 12 months immediately preceding the registration or renewal, the number of unit owners that were at any time during the 12-month period 6 or more calendar months delinquent in the payment of assessments or special assessments. And there's 4 required questions total. Number 2 is for the same period of time, the number of unit owners against whom the association or its designee obtained a judgment. Number 3, for the same period of time, the number of payment plans entered into between the association and a unit owner pursuant to section 316.3. And then the last required question on the online application is for the 12-month period for unpaid annual assessments or special assessments or related fees or attorney fees, the number of foreclosure actions filed against unit owners pursuant to section 316. So those are requirements that were put into the bill by the Colorado General Assembly, by the prime sponsors of the bill. So in working through these questions, the HOA Center came to the conclusion that, hey, maybe we can actually, improve our data collection processes and improve our annual reports with certain additional information that might be helpful for the public to understand about common interest communities. So these are optional questions. So as you're working through the application, you'll see the question However, you will be able to advance in the system without inputting a value or answering these questions. They're optional. So the number of board positions identified in your association's governing documents, so that might be 3, 5, 7, 9. The number of vacant board positions on the date of the registration, the current average assessments in your community, the frequency by which assessments are due, so whether monthly, quarterly, semi-annually, or annually. For the 12-month period immediately preceding the registration, the percentage change in assessments. So what the percent change was. Identify the number of payment plans. Yes, I'm sorry. I confused myself. Number 6, for the 12-month period immediately preceding the registration, identify the number of payment plans offered by the association. So that's different from the required question of entered into between the association and unit owner. So how many payment plans were offered by the association? And then one can come to the conclusion that, okay, the association offered a payment plan, but the delinquent owner refused to accept the payment plan. Number 7, identify the number of unit owners on payment plans who satisfied the terms and conditions of that payment plan. Identify the total amount of late fees and interest collected as a percentage of total revenue. And then the last optional question, again, these are just optional questions. Identify the total amount of late fees and interest assessed and waived as a result of a payment plan. So some of this information is intended to gather certain facts, I guess, about, maybe this community is experiencing has a lot of delinquency. However, the board has made concerted efforts to reach out and offer these payment plans, and they even went as far as to waive late fees and charges in order to arrive at an amicable solution with a delinquent owner. Okay, so key takeaways for this presentation. Let's say number 1, ensure that you are following proposed legislation as it's making its way through the Colorado General Assembly's legislative session. For 2026, that session, according to the General Assembly's website, convenes on January 14 and generally concludes in the second week of May, pending any special sessions. If you are an attendee on this call and you're interested in participating in the legislative process, I would highly encourage you to review the following information provided by the Colorado General Assembly, which is a citizen's guide to effective legislative participation. There is a link there, but and just in case you're unable to click it, I did include the actual link below. So ledge.colorado.gov, so etc. If you're a board member, community manager, make sure you're reviewing the existing collections policy on a recurring basis. Maybe that's, once or twice per year, maybe, just to ensure that everything jives with current statutory requirements and all the information is accurate and updated. If you don't have a current collections policy, you absolutely need to get on the ball with that and adopt one. The board has to adopt and approve a collections policy for how it collects assessments from owners, from members. Consider speaking with a qualified attorney for assistance in updating your policies. To my knowledge, there's no statutory requirement that an HOA has to speak with an attorney in order to update its policies. However, there are many law firms in the Denver area in Colorado that specialize in common interest community matters, and your community, your board might consider reaching out to a couple to understand their pricing requirements and their backgrounds and how experienced they are with community association matters. And then finally, just, well, not finally, in the HOA registration and renewal applications, there are 4 new required questions as denoted by a red asterisk. and 9 new optional questions. No red asterisks on those questions. So if you're a board member, and also, proactively search for a mediator. If you don't already know somebody, before a dispute starts, before arguments ensue, it might be a good idea for the board to do some research and find some qualified mediators in Colorado who maybe they can act as like a go-to or an on-call mediator. And then suggest them as a trusted source in your community to use as a go-to mediator. The Colorado Judicial Branch's Office of Dispute Resolution offers affordable access to qualified mediators and could be a good resource, as well as the Mediation Association of Colorado, which should also help you find a professional mediator near you. Okay, so that concludes the presentation on House Bill 25-1043 and an HOA's collections and assessments. I hope you found this presentation to be helpful. Feel free to contact us if you had any follow-up questions or concerns. I'm always interested to hear feedback, whether you whether you thought this whether you think these presentations are useful or not. Feel free to send an email with your feedback, and if you know of any topics that you feel the HOA Center should present on in future presentations. And then with that, I wanted to see if there are any questions in the Q&A that David or Amanda might want to share.
Nick, this is David here. Amanda and I have been answering several questions in the Q&A, so certainly I would encourage anyone to take a look at those while we are chatting about some things verbally as well. But a lot of questions, there's been an interesting theme which I wanted to bring up with everyone, just to kind of call it to your attention. There is a legal distinction between filing a lien and foreclosing. And so some of the questions that I've seen have first and foremost, I've seen several questions where they say, well, we don't foreclose in our community. And now, as a practice, that very well might be a great thing. I'm sure that your neighbors are very appreciative. But however, it commonly is a last resort, or should be considered as a last resort, in my personal opinion. But it also is a situation where just because you don't do it in practice, more likely than not, you do in fact have those legal authorities to foreclose. And so the questions that I've seen have been like, well, we don't foreclose in my community, so do I have to pay attention to the information that Nick's talking about here? And in reality, yes, you do, because your governance policies, like your collection policy that Nick has spoken about so many times here today, that is something that is required to be put in place, whether things are going well or if they are not. You need to have an effective, proper collection policy in effect in order to collect dues. And so, and if you don't, then someone could simply say, well, I don't have to pay you. While that's legally probably not accurate, it creates a situation where you're just getting on the road to a legal fight, and ultimately a court case, and potentially, yes, ultimately maybe something as severe as a foreclosure. So getting these things in place is proper, whether or not you intend to ever foreclose as a board member. Again, you have a fiduciary duty as a board member to your community, and therefore, just because you don't want to foreclose on someone doesn't mean that you're not supposed to if you are carrying out your fiduciary duties. Of course, all board members should do their very best to work with community members, to negotiate with them, to mediate perhaps, all of these other steps that Nick's talked about. However, it is ultimately a consideration that is on the table, and that all board members and community members should be prepared for in the event of maybe what I'll refer to as extreme scenarios. So then one other thing I wanted to mention, Nick, while you're looking through some of the Q&A here is if there's the difference between filing a lien and filing a foreclosure action. Commonly, you file a lien first, and then if the lien is not satisfied, you have the ability to proceed towards a foreclosure. Now, in Colorado, we have what is called a super lien, which means that an association gets to step up in priority for the amounts related to up to 6 months of association dues. And that's what we refer to as the super lien. You get to the association gets to jump in line in front of your mortgage companies, for instance, in that situation. So that's why it's called a super lien. But liens can be filed against failure to pay your dues, but also liens can be filed for purposes such as late fees and interest and attorney's fees. However, it is very important to note that that associations may not foreclose on a homeowner for fees, interests, or fines alone. That is not permissible under Colorado law. As of last year, perhaps the year before, forgive me for not having that information in front of me right now, the law changed and expressly states now that you can only foreclose, that an association can only foreclose for on assessments, not on interest, not on legal fees, although a lien can be filed against those things. So I know that is a muddy, I probably made that as clear as mud for you all, but those important distinctions of between what a lien is for and what a foreclosure action are for is definitely a complicated and an important concept to consider. So we always suggest that you consult with a legal counsel in those types of situations.
Yeah, I'll just mention here too that this presentation is being recorded. Probably should have mentioned that at the beginning, but and we will upload a copy of this presentation to the HOA Information and Resource Center's website. And actually, if I can get, yeah, I was going to do a quick kind of a drive-through tutorial while we just have a couple minutes left here for the presentation. For A, how to actually get to our website, and B, how to find additional resources that you might find helpful. So if you first navigate, using a web browser to dora.colorado.gov, this will take you to the main overarching Colorado Department of Regulatory Agencies website. So then from here, you'll want to go to the Division of Real Estate, which if you go to divisions and programs, you'll see that there are multiple divisions and programs within DORA, and the HOA Center is a program within the Division of Real Estate. So you'll click on Division of Real Estate. That'll take you to the Division of Real Estate's main webpage. From here, you'll go to Division Programs, and you'll scroll down to HOA Office, and that will take you to the HOA Office's webpage. So that's hopefully that helps out a little bit, at least on how to get to our webpage. Of course, you can also just manually type in the URL dre.colorado.gov/HOA-center to get to our webpage. Also, if you don't currently receive notifications and updates from the HOA Center, you can enter your email address at the bottom right here for sign up for HOA Today. We do our best to send out up-to-date information and notifications regarding to pertaining to HOAs in Colorado, and information that we think you would find interesting and relevant. Also, so if you're kind of wondering where is that link that we can include in our collections policy, that will be under this header here As you can see, there are multiple headers: file a complaint, register your HOA, recent HOA forums, and then you see this one right here, assessments and delinquency info. So if you click on this, you'll be directed to a page that contains information on assessments. What are assessments? How are assessments calculated? Various other tidbits and helpful information that a delinquent homeowner hopefully should be aware of and educate themselves about some of the resources that are available to them. And last but not least, I wanted to, since there still seems to be confusion, and I'll be the first to admit, it's very difficult to understand how to read and interpret bills that are passed by the Colorado General Assembly. I just kind of wanted to go through this a little bit real quick here to hopefully help understand what is a bill, how do I read a bill, and how do I apply it to existing law. So if you type in, if you go to a web browser and search for the bill you're interested in our case, it's House Bill 25-1043. You'll click on the Colorado General Assembly's first link here, which will take you to a summary of the bill prepared by the Colorado General Assembly. If you scroll down, well, you can see, obviously there's a summary here. But if I wanted to direct your attention to view recent bill text. So if you click on that, it will take you to an actual copy of the act or the bill, which is how the bill is changing the Colorado revised statutes. So this isn't the actual law. Rather, this is how the bill is amending the law. So, for example, if you look at section 1 here, in Colorado revised statutes 1210-801, amend 3C as follows. So it's essentially saying, take this information here and amend, not this information, this information, because capital letters or bold or in italic numbers indicate new material added to existing law. So if we take that concept, we see here that this language here is capitalized, right? So what the bill is saying take this new language and add it to 1210-801. So if you pull up a new version of Kiowa, you'll see, well, that's not a good example here. If you pull up a new version of Kiowa and go to section 3833.3-123, you'll see, you're not going to see this new language capitalized. Rather, you're just going to see an addition to that section, which will contain this new capitalized language. It's important to note too that the uncapitalized language is not, this is not being added here. If my computer cooperates with me, which is not, but in determining reasonable attorney fees, that section right here, this is not new language. It's just existing language, which should help with an understanding of conceptualizing or interpreting how this new language is affecting the existing law. So hopefully that was your Colorado General Assembly educational tutorial for the month. But okay, I think that about wraps it up, unless there are any other final comments or notes for Amanda or David.
Just one other very, very quick comment for everyone. There were a few inquiries about whether or not your presentation today pertains to timeshare communities, timeshare estates, as well as Kiowa communities and pre-Kiowa communities, etc. And in the bill, what Nick is actually sharing with you on the screen right now, there are actually two carve-outs specifically, expressly, that state that it is section 4 and section 6, I believe. Nick's showing you section 4 right now of the bill, expressly taking out the applicability. I apologize. I thought you were looking at how. Oh, you are looking at House Bill 1043. But it was section 4 and section 6 expressly do not apply to timeshare units. So that would require a little bit more detailed review. but generally speaking, Kiowa is very, very clear when it states that that any given section does not apply to a timeshare, for instance. It will state so. So carefully reviewing the actual statutory language is an important step there.
Yeah, thank you, David. Okay, well, thank you again, everybody, for let me just get my contact information screen pulled up here one more time. Thank you again, everybody, for attending. We hope you found this information helpful. Yeah, that concludes our HOA forum for this month. Next month, we will be talking about special assessments. So stay tuned for an announcement on November for special assessments, which is a topic everybody loves. So again, yeah, thank you everybody for coming. Feel free to share your comments and suggestions, and I hope everybody has a great weekend. So again, thank you, David. Thank you, Amanda, and bye. Goodbye, everybody.
Thank you.